This is the second video for weeks 5 to 6. It's a screen shot video posting 7, which I put up last week, criminal liability for the conduct of another and anticipatory offenses. Let me start with a story that I don't have in the posting. A true story. A while back, which in my case is probably 20 plus years ago, I was doing criminal defense work from time to time, and a person came to see me, and he was out on bail, and he was, I think, lawyer shopping, but he had been charged with arson. And I distinctly remember him saying to me, I don't even know why I was charged, but it will be very easy to represent me because there's no way I'm guilty of arson. And he went on to add that on the day the building I own burnt down in the city of Buffalo, on that day I was in Fort Lauderdale, Florida. I have airline tickets, receipts to show that I was there. I have hotel receipts to show that I was there. And I was with a traveling companion who will corroborate my claim that I was there. In fact, I was there for a week and the building burnt down in the middle of that week. So how could I be guilty of arson, he asked. And I remember asking him just a few questions. I asked him, well, number one, if you know, and he did, was your business in which you were conducting in the building, was that not doing well? He goes, I was having trouble. I was struggling. And I said, number two, do they claim that you hired somebody to burn down the building? He goes, yeah, I don't know how they can charge me with that. I didn't know the guy, etc. Well, of course, what had happened is this. The state's theory of the case, and I never represented the guy, but the state's theory of the case was this. The defendant who was speaking to me was guilty of arson, not because he actually put the gasoline in the match to the building, but because with the intent that the building be burnt down to collect the insurance, he hired someone to burn the building down. And under Section 20 of the penal law, he was as liable as the arsonist himself. And I have broken down Section 20 in a way I think it makes a lot of sense. One person can be criminally liable for the conduct of another person if they act with a mental culpability required for the commission of the offense and either ask or intentionally assist the other person in committing the crime. When we look at the language of Section 20, we see that they use the legislature solicit, request, commands, and importunes, but those are just 4 different ways of how we can ask someone to do something. And so I have shortened it to ask. And so to get again to the guy who spoke with me, he had the mental culpability, namely the intent that the building be burnt down. And by hiring somebody, he asked that person to burn the building down. Notice here it's either or, and he didn't have to be there assisting the guy because it was enough that he asked the guy, by hiring him, to burn the building down. A classic example of how Section 20 works, I'm afraid that this might be dated these days, especially since Mob Wives isn't on television. But if you looked at Mob Wives, which was certainly one of my favorite shows, and I'm still grieving the loss of Big Ange, but one of the characters on this reality TV series, which was somewhat hilarious, was Karen Gravano. And her father, I think he may have passed away since then, but was Sammy Gravano, known on the street, of course, as Sammy the Bull Gravano. and Sammy the Bull was a lieutenant in the John Gotti crime family, and Sammy gets jammed up, and how he gets out from underneath being jammed up is he agrees to give evidence against John Gotti, who at that point was known as the Teflon Don, because the government, federal and state, never seemed to be able to convict him. And what happens now is Gotti's charged with a number of murders that were actually committed, or the trigger person was Sammy the Bull. But what Sammy the Bull was able to say is that he murdered people at Gotti's direction, because Gotti wanted the people out of the way. They were interfering with his business in some way or another. So if you look at Section 20, Gotti had the intent necessary for murder, intent to kill, and he directed Gravano to commit the murders. And again, he asked him, therefore, to do it. Gotti didn't have to be there holding the person down to be shot. It was enough if he asked him. Notice, either ask or intentionally assist. And that's how John Gotti went down, and that was the end of his career, as at least we think it was. He died in prison. So Gotti didn't pull the trigger. He wasn't present at the scene, but he was liable for the murders. By the way, Sammy the Bull went into witness protection program. That's how badly the government wanted Gotti. And he went, I think, then to Arizona, where he got involved in more criminal activity. I offer you another example of Section 20, where a defendant, this was taken from a real case, drove his cohorts, right, to the immediate vicinity of a robbery. He parked 2 blocks away from the store where the robbery took place, and watched his cohorts exchange loaded guns, waited for the return, and then drove one of them away to dispose of the guns. And according to the court, that was sufficient evidence to hold the defendant liable for the robbery, even though he wasn't present at the actual site. By driving the getaway car and seeing the guns, knowing what happened, established that he wished to participate in the robbery. That's meant that he had the necessary element of mental culpability, and by driving the getaway cars, he assisted in the robbery. So in this case, unlike Gotti and my arsonist, it wasn't that he asked somebody to do it, but he assisted them, and he had the intent, as did the arsonist and as did John Gotti. There's a case where liability was not established. And this is, I've got to scroll down, and I apologize. We're having some technical difficulties. But in any event, this is a case where a person was charged under Section 20, but the court found there wasn't enough. So what happens is the defendant was observed inside a bar shortly after 1:30 on a night where another person shot someone to death just outside the bar. There was evidence that the defendant was staring at the victim in the bar. There was also evidence that the defendant owned a certain type of vehicle that was observed near the bar before and after the shooting. And there was also evidence that the shooter, the person who actually pulled the trigger, approached the victim on foot after the victim left the bar with his girlfriend. And there was also evidence that the defendant and the shooter, the killer, exchanged phone calls after the shooting, and that the shooter was picked up in a vehicle matching the defendant's vehicle and was then driven to the shooter's home. And based on that proof, the court found that the defendant's presence at the scene couldn't be considered sufficient for finding a criminal liability. There was no evidence, the court said, that would permit the reasonable possibility that the defendant necessarily had knowledge of the shooter's intent, and without intent, there's no basis for holding the defendant liable for murder. The evidence simply didn't establish the requisite intent, the court said. And then I want to point out where we're going next, and I'm going to do it in a separate video. We're going to study the anticipatory offenses, and those offenses are going to address situations where it may not be possible to hold a person liable under Section 20 of the penal law, like Gotti and like the arsonist, but the person nevertheless can be held responsible under a lesser severe crime known as one of the anticipatory offenses. So we'll do that in our next video, because I can't finish off anticipatory offenses in 4 minutes.